Take two.
Take two. So tonight we're going to talk about information for adult children caring for their parents. I'm going to go through some of the resources and things you want to think about when you are caring for your parents, both when you start and when you're right in the midst of it. As always, if you have questions, feel free to interrupt me and I will just get started.
Okay.
So there are many different ways in which people can give care for their parents. So this is kind of a big topic. It covers a lot of areas, and sometimes people think we're just talking about caregiving, meaning you're helping someone bathe or putting them in bed or transitioning, those sorts of things. But it can be even just assistance with errands and appointments, which is kind of the lesser side. Maybe you don't even live with them and you just live across town and you take them to their doctor's appointments, run errands, bring them groceries. It can be daily help with activities of daily living. Again, not living with that person. You can be just doing that kind of assistance, going over there every day. I've had plenty of clients who will have maybe mom can't shower very well for herself, isn't safe to be in the shower. And so they'll go over there once or twice a week and help with that. It can be in-home living and care, meaning that either your parent lives with you or you live with your parent and you are caring for them daily and maybe even doing all of the care they need. It can also just be assistance with a parent who lives in an independent living. So this is a situation where they live in a home with other seniors and they're independent living, which means that the facility that they're in doesn't actually provide them with assistance with activities of their daily living, but instead maybe just provides food, shelter, and maybe socialization, those sorts of things. But then that person actually has someone else come in, and maybe it's a child who comes in to assist that parent with what they actually need for care. First thing to look at always is what documents are in your parents' estate plan. This is something that you should look at while your parents are still capable of doing so. And even though it's a difficult situation and difficult conversation to have, it needs to be had. These documents are important. You need to understand what each one of them does and why they're important. And if your parents don't have them, then maybe talk to them about getting them in place before it gets to the point where your parents are unable to sign things for themselves. So they may have a will. They may and should have powers of attorney for healthcare and for finances. They may or may not have a trust, and they should have a HIPAA authorization and a healthcare directive for sure. I'm going to go through each one of these. Wills only take effect when you pass away. So this is a document that tells everyone what your parents want to have happen with their assets when they are gone. They will name a personal representative or an executor, depending on what state you're in. That's what that term could be, either one. And that person must do what your will says. So whatever your will says, that person's job is to take the document, get appointed as personal representative or executor, and then do whatever that will says you wanted done with your property. You combine your will with a personal property memorandum. And that personal property memorandum is a sheet of paper where you say, I want these people to get this particular piece of property before everything else goes through my will. And you may also have a codicil, and your parents may have a codicil. This is pretty common for people who have older wills. If they wanted to make a change to their will, rather than redoing their will, they would do what is called a codicil, and that would change a section or a portion of their will. If they do have a codicil, you want to make sure you know where both the will and the codicil are. And anyone can include a testamentary trust in their will. So we're going to talk a little more about trusts. I'll talk about the difference between living and testamentary trusts. I don't want to spend too much time in detail on each of these because we've already done a couple of sessions on these documents themselves, and I'm happy to answer any questions on them. But I really want to kind of stick with how this matters in terms of adult caregivers. So powers of attorney, this document designates someone to act on your behalf when you can't act for yourself. That person is called the attorney in fact, and they must act according to that person's direction or in their best interest. So this is really important for adult children to understand, because sometimes I see this conflict come up where this child will be named in their parents' documents as their attorney in fact. And maybe the parents are making decisions that the child doesn't agree with or doesn't think are the best decisions. Well, you don't get to make that decision for your parents. So if they nominate you as their attorney in fact and say, okay, I want you to help me with these things, that's your job. You help them with the things you do what they say they want done. You cannot override their decisions. You can't make decisions and substitute your judgment for their judgment. And if they tell you not to do something, you can't go and do it. So sometimes I will see situations where adult children think that their parents are not making the best decisions that they could, and they really were trying to protect their parents, but that's not how this document works, and it doesn't give you the power to do that. And in fact, as a caregiver or an attorney in fact for financial decisions, if you do what your parents told you not to do, that's illegal, and it's a violation of your job to help them, your fiduciary duty towards them. So you got to be really careful to make sure that you are doing what they're telling you to do, what you know their wishes were, and what's in their best interest. Durable power of attorney stays in effect until a person's death. It's called durable because the duration lasts beyond their incapacity. Parents should have two of them, one for finances and one for healthcare if possible. If they have one that is both and they don't have the ability to make new ones, that's okay. It doesn't mean you can't use them. It's just going to make your job a lot easier if they have separate ones. And finally, just like I tell everyone else in all of these presentations, and anytime this comes up, these are the most important documents any person can have while they're alive. And if you are the caregiver for your parent, this is the document you're going to use all the time to affect the decisions that you need to make on their behalf or the things that they've asked you to help them with. This document is what you're going to need to be able to do those things. You want to make sure that it is very thorough, that it's in good shape, and that it's effective immediately, preferably, or upon their disability. Then you need the doctor's note to make sure that that is a document you can use now. But this is really, really important. It's vital. Trusts. Trusts can come in several different forms. They can be standalone living trust or a testamentary trust created by a will, like I talked about back a couple of slides. The person who creates the trust is the trustor, and the person who gets the benefit of the trust is the beneficiary. The person who manages the trust is the trustee. Now, this matters a lot more in these situations where you have adult caregiving children, because sometimes those children are also going to be the successor trustee if their parents are incapacitated and have a living trust. In Washington, a living trust is not the best way often to set stuff up. But if that is what we're working with, that's where we go, and that's what we do. And in other states, the living trust is useful and helpful, and some people will have stuff set up that way. So it's important to understand how they work. If you are the trustee of a trust, then your job is to make sure that the beneficiary gets the benefit of that trust. I have an example again here in the next slide. A revocable trust can be changed later or ended by the trustor. And remember, that's the person who created that trust. Usually it's going to be the parents in this kind of a situation. An irrevocable trust cannot be undone by the trustor. So if it's a revocable trust and your parents took some money and they set it into this trust and they're the beneficiaries of that trust, they can change their mind and take that property back if it is revocable. If it is irrevocable, then it cannot be undone by them. That money they can't take their money back. How does a trust work? Again, this is a very simple example of what a trust is. So when you create a trust, instead of giving a gift to someone, you give it to someone else to use for that person's benefit. So the example I use here, if you wanted to give Benny $100, but you don't want Benny to buy candy with that $100, then you don't give the $100 to Benny, because you know that that's exactly what Benny's going to go and do. Instead, you give it to Trudy and ask Trudy to spend the $100 on Benny, but not to buy candy. So that's a simple example of a trust. Instead of giving the money directly to someone, you have someone hold it for their benefit. A revocable living trust is a little bit different. And well, it's not different, but when people are creating a revocable living trust in order to avoid probate or to hold their property for whatever reason, what they're generally doing is making themselves the trustee and the beneficiary of that trust. And of course, they're the trustor because they put their money into it. So what they're doing in those scenarios is saying, okay, well, I'm a trustee, so I'm in charge of everything. I'm also the beneficiary, so everything in this trust can be used for my benefit. And I'm the trustor, I created it. However, sometimes we'll have successor trustees in these cases, and the successor trustee might be that caregiving child or the child who's assisting their parents with things. And what they will do then as successor trustee is they'll be in charge of the assets of the trust, but the parents are still the beneficiary of that trust. So those assets still need to be used for the benefit of the parents, not anyone else. But it may sometimes come to pass that the parents are no longer the trustee because maybe they don't have the requisite capacity to manage those affairs right now.
Just a quick question on that. So if you have the scenario that you just described, however, the spouse is not incapacitated, what happens then?
Generally, if two spouses together have created a revocable living trust, they will be named as initial co-trustees. And what they'll usually say is that if one of us is incapacitated, the other one's going to be the trustee. If we're both incapacitated, then, kid is going to be the trustee. So it depends on the terms of the trust, but that's generally how those work.
Okay.
Another really important document, healthcare directive. So this is also called a living will. This is what tells your doctor and your attorney. In fact, remember that in these scenarios is usually going to be the caregiving child that we're talking about here. What you want to have happen if you're at the end of your life and you're either unconscious or in a vegetative state. As much detail as possible can go into these, and let me tell you, having seen all the situations I've seen and with the death of my own parents, the more detail about what you want, the better. It makes it much, much easier on the people who have to make those decisions. So if you're a caregiving child, you want to make sure that you have gone through this document with your parents and understand every piece of what they want to have happen, because believe me, it's hard to think of all of the scenarios that can happen at the end of one's life. So having those conversations and really understanding the different things that could happen is going to make it a lot easier in the long run if you ultimately have to make those decisions for them. So that's, the more thorough you are, the better. This covers different situations than a POLST. A POLST is a physician's order for life-sustaining treatment. That document covers what happens in an emergency, not just when you are unable to speak for yourself and you're, lingering on machines keeping you alive. A POLST is a doctor's order, so it has to be signed by a doctor that says whether or not paramedics who show up at your house are going to do CPR. So they kind of cover the same idea, but the situations are different. And so you really want to have both. You want to make sure that they match up on the longer term stuff, but you need a pulse especially if you feel really, really strongly about having a do not resuscitate order. Okay. Then you definitely want to have a pulse, and you want to have copies of it placed everywhere, because of course, emergency situations, paramedics, they're going to try to save your life. And if what you want is for them to let you die, you need to have a pulse for sure. But you can have both and should have both because they cover different situations. So what if the parents don't have a power of attorney? This comes up sometimes, less often than it used to, but it still does. If your parents don't have a power of attorney and you need to act for them, then you have to get a guardianship. There's really no other option. Guardianship is also called a conservatorship in some states. A guardianship is when a court chooses your guardian and chooses who's going to make financial and healthcare decisions for you forever. And that person then gets to override your decisions. You get your rights taken away in a guardianship. You can lose even constitutional rights in a guardianship. And so we try to avoid it at all costs, if at all possible. by having a good power of attorney. But if you don't have one, then this is your option. The court chooses a guardian, and then that guardian will be ordered to report to the court, certain, like every year, every 2 years, every 3 years, for the rest of the person's life. And all major decisions that you make must be approved by the court. So you can make minor, normal day-to-day decisions, but like if you wanted to sell their house, you have to go ask the court if you can sell their house. If you want to move them to a certain facility, you have to go ask the court if you can move them to a certain facility. So it becomes.
I have a question about this. So if your parents, for example, like this doesn't apply to my dad, but maybe my mom. So if my mom doesn't have a power of attorney, something happens to her, I get a guardianship, and then she recovers. Does the guardianship, then what happens?
She can petition the court to end the guardianship.
Okay. Okay.
So there is a process there, because that does happen sometimes. So most of the time it doesn't. Most of the time when you get to the point where a guardian really needs to be appointed, people don't generally cover from those situations, but it does happen. And there are methods by which you can go and petition to have a guardianship removed.
Okay. Yep. Thank you.
So guardianships, overall, they're expensive, they're time consuming. So if your parents still have the ability to create a power of attorney, have them get a power of attorney, even if they do none of the other documents that we're talking about. Even if you think they have no assets and there's no reason to do it, go and get a power of attorney, because even if they don't have assets, you still have to go to get a guardianship if you need to make healthcare decisions for them. So get a power of attorney if at all possible. And then HIPAA authorization. So this is the document that lets doctors share information. And so if you're not on your parents' HIPAA authorization, you're going to have a really tough time being involved in the doctor's appointments and in any decision-making that needs to happen as far as healthcare goes. So you want to make sure that you are on their HIPAA authorization. You're allowed to get information from their doctors and hospitals. There should be one in their healthcare power of attorney. I like to do a separate one as well, because I think it's nice to have a portable one, because you may or may not be somewhere where you have previously signed an authorization when care happens. And, I've had people traveling out of state on vacation, and something happened, had a stroke, ended up in the hospital and far away in a different state. They didn't have their healthcare power of attorney with them. And they didn't have the HIPAA authorization that they had signed with the hospital back in the state where they live plenty of times, and with their doctor, and thought that that was enough. And so then I've had to fax the HIPAA authorization that I do, that's a separate document from their healthcare power of attorney. It's very useful to have that. Also then, if your parents have somebody who they want to be able to talk to the doctors, but maybe they don't want that person making those decisions, then they can have them on that HIPAA authorization, but not on the healthcare power of attorney. Asset protection trusts in Washington. Now this goes for Washington, not for every state, but revocable living trusts here in Washington provide very little benefit for anyone. So especially for couples. And in fact, they can actually get in the way of asset preservation for couples. So if your parents are couples, are still married, and they have revocable living trusts as the basis of their estate plan, then they should really talk to an elder law attorney. It's very important for us to at least take a look and explain why they may or may not want to change that. If they don't have capacity, of course, they may not be able to change it. But if one of them has capacity, it may still be worth changing. This is a thing that sometimes people don't think is possible. So, have, a couple, and one of them has dementia and can't change their will, and the other one could change their will, but they think, oh, well, if we both can't change it, it's not worth it. That's not true. There's asset preservation that can be done from even just one spouse of a couple. So even if that is the case, still go and talk to somebody, because there may be some protections and some things that can be done.
If they have, I'm just thinking of a situation that a friend of mine's mother is in the state of Iowa. And so they have a trust. That's why I keep asking these questions about the trust. So if they have a trust and the children are the, trustees and all the things, the spouse his mother is not the mother of the children. And so the dad is incapacitated at this moment, and so she should go and talk to an attorney
Yes.
because she's
Yeah.
really worried that she's going to lose her house and all of the things once he passes away. So
Yeah, she should definitely go and talk to
okay,
someone. Yep.
okay,
Yeah, even if one member of the couple is incapacitated, the other should still go and talk to somebody.
okay,
Because very very few of the people who come to see me in those situations have an estate plan that's already built properly for one of them being incapacitated and needing
sure,
care. It's not to say never,
right,
but at least go and talk to somebody and have the conversation and make sure that what you have is the best for that situation, because those things kind of they change as time goes by. And so even if one is incapacitated, the other should absolutely go and talk to an elder law attorney.
yeah, because I mean, she's absolutely terrified she's going to lose her husband, and she's scared that she's going to lose her house. So I was like,
Yes.
yeah, she should
And
go talk to somebody.
it's far better to talk to somebody now rather than after he's gone and then find out that also you're
Right,
losing.
that is true. Right, exactly. Okay, thank you.
All right, caregiver contracts. This is something I can't stress enough that people should start early and understand the rules in their state. Most of the rules are similar to this one because, again, Medicaid rules for different states are based on a federal guidelines. They are not exactly the same in every state, and you should talk to somebody in your state to get specifics, but it's going to be similar. And this is a thing that's this nuance to Medicaid planning is something that's going to be pretty similar in every state. And also you need to understand how this works before you get too far down the road, because if you don't do this right at the beginning, you're going to lose out on some ability to make sure that somebody can get Medicaid later. So if you are caring for your parents and they want to pay you, this is the situation that this comes up in. You want to make sure that you do it with a contract, because if you do not, if your parents are paying you, say, $1,000 a month to provide them with care, say mom needs care a couple of days a week, and she pays you $1,000 a month to do that, and it's a thing that you've got in place and you've had it in place for, say, 2 or 3 years, mom eventually needs more care, can't afford it, and needs to get onto Medicaid. Well, mom has been giving you $1,000 a month. If you don't have some way of showing the state that that money was given to you for caregiving, then they may penalize her ability to get Medicaid because they think that she's been gifting.
Okay.
So the way that you get around this, and the way that you not get around's not the right word for this. The way that you demonstrate this to the state is with a caregiver contract. And each state is going to have specifics. They're going to look a lot like this in every state. This is Washington's specifics. So you must have a contract, it must be in writing. This piece, it must be paid within 30 days of when the care is given. That means that if you give care, you must get paid for that care that you gave within 30 days. So if you get paid $1,000 a month, you better get paid once a month or more often. If you do not, then even if you've got the written contract, and even if you were paid the right amount and it was a completely fair amount, and it's the market rate for somebody giving care that way to your parents, you can still jeopardize their Medicaid benefits if you don't have it, if you weren't paid every month. I see sometimes people will do this and they're meaning to do this right, and they miss that piece. And so, they'll care for their mom for 6 months, 8 months, and then she'll pay them $6,000 or $8,000 for that care. And then she'll go and apply for Medicaid, and they'll deny her because she wasn't paying that care within 30 days of when it was given. So these pieces are very important. You have to be specific about the amount of money paid for care. So it's not that you can't pay someone a good wage for it. You can, especially as the market will bear much higher wages than you would think for this kind of in-home care. But you got to be specific about, this is the care I'm giving, and this is how much I'm getting paid for it per month. It must be for care that Medicaid would allow under their rules. What that means is, if you're saying this is a care contract and you are, going in and taking care of mom, maybe helping her get her dinner eaten and take a shower, those sorts of things, That would absolutely be allowed under Medicaid. If what you're doing is going and sitting and playing video games with mom, and mom doesn't really need any care, really she just wants you to sit there and play video games with her, but she can take care of herself, that's not care that Medicaid would allow under their rules. They wouldn't get paid for, they wouldn't pay for a caregiver to do that. So it needs to be something that they would pay for a caregiver to do, which doesn't have to be super high level of care either, but you do need to make sure that it fits within that definition. And then you need a doctor's note or some other documentation regarding the need for care. So you can't just say, mom really needs me to take her to the bathroom twice a day, but really all mom needs is for you to sit there and play video games with her. That's not, you need to have some kind of documentation. It doesn't have to be extensive, and it doesn't have to be every day, and it doesn't have to be a full care plan from a social worker, but you need at least a doctor's note that says, mom needs help to the bathroom sometimes, or, can't be left alone for more than X number of hours at a time. There's just some kind of documentation regarding the need for that care. So if you do need a caregiver contract, either go have an elder law attorney draft it for you, or have them at least look at it, because you want to make sure that you're not missing any of these pieces. And then 2 or 3 years down the road, mom needs Medicaid and she can't get it because they're saying, well, she gifted you money because you didn't fulfill this piece of the caregiver contract rules. How can you get paid by the state? So in Washington and in several other states, the state will pay you to care for your parents. You can ask the state to pay for you, or to pay you to care for them. There are some rules about that. They must be living at home. So if they're in a facility, nobody's going to pay you to go in and care for them in a facility that's already providing care for them. So they must be living at home, and that can include independent living in the scenario that I talked about in the very beginning. That can include independent living in a facility as long as the facility is not actually providing care. They must be eligible for Medicaid. So that means they've got to be financially and physically eligible for Medicaid. And you're going to have to this time get an assessment done by the state, and then your care plan, you're going to work it out with the state as far as how much care you're going to provide for mom that you're going to get paid for. Obviously, you can provide more care, but the state's going to limit how much they're going to pay for. And you must become an individual provider for the state of Washington here, or whatever state you're in. You're going to have to follow the rules here. It takes about 80 days to get from start to finish to get fully qualified as an individual provider. There's a few classes and online stuff that you have to take, and then an application process. You must not have any criminal history and must be eligible to work in the United States. Those things are pretty common to working for a state anywhere. But if you do all those things, then you can get the state to actually pay you to care for your parent. Oh yeah, and you can't be the spouse of that person. So the state assumes that it's your job to take care of your spouse. So you can't get paid to take care of your spouse. But they don't assume that it's your job to take care of your parents. So if it's a parent who needs care, you can get paid to do so. Or a friend, or really whomever you're providing care for. So how do you pay for care if you don't have the state paying for it? So your parents can pay for care with their personal income and assets. Medicare for rehabilitation only. That's only if they fall, they go to the hospital, they're there for 3 overnights, and then they go to rehab in a skilled nursing facility. Then Medicare will pay for that, but it maxes out at 100 days, and it can stop sooner than that. If your parents have long-term care insurance, that will help pay for care of all levels. VA aid and attendance benefits for wartime veterans, and Medicaid benefits, of course. So I'm going to go through each of these a little briefly here. Personal income and resources. Anyone who needs care can pay from their own income and resources. This is kind of a no-brainer, but we always start here. How much income do they have each month? How much does their care cost? And how much do they have in other resources? Most people who are over age 65 have a lower income, so their resources are going to dwindle over time because the care needs are going to increase. The income is going to stay constant. It's going to be lower than it was when they were working. And so their resources are going to have to come make up for that. and eventually they're going to dwindle down over time. Also, many facilities, if the person is moving into a facility, has a private pay requirement of 1 to 3 years. And what this means is if your parent is eventually going to need Medicaid, they're going to go into a facility. That facility is going to say, okay, well, first you need to pay for a year or 2 years or 3 years of time here out of your pocket, then we'll let you go on to Medicaid. The reason I bring this up in this context is you need to be planning ahead for this stuff. So if you're caring for your parents at home and you think you can care for them and you have a good setup and maybe they live with you or you live with them, and you're going to be able to provide that care until they die, then it's not as much of a requirement. But sometimes you're going to not be able to, you can provide care for a while, but there's going to be a stopping point, a point beyond which you cannot provide enough care. And if that's the case, you need to look ahead at what are they going to need left over with their resources and their income in order to pay for that private pay requirement that they might have at a facility. Medicare, as I mentioned, you have to stay overnight in the hospital for 3 nights before being admitted to the facility. You must be admitted to the hospital, not just under observation. You got to watch out for that. This is a thing, as the child of a parent who needs care, this is a thing that you really want to push and ask about at the hospital. So if your parents are admitted to the hospital, make sure they actually got admitted and that they weren't just under observation. If they are under observation and then they need to go to a facility or go to rehab, Medicare is not going to pay for it. So you really want to push this with any hospital if your parents have to go to the hospital for any reason. Medicare only pays for skilled nursing rehab. And this care is almost always received in a skilled nursing facility. Rehab is generally intensive and it's in a rehab facility, it's always skilled nursing. Medicare will pay 100% of the cost for the first 20 days and 80% for another 80 days. If you have supplemental insurance, this is usually one of the big holes that fills, is that extra 20% after the first 20 days. And finally, you're not guaranteed 100 days. This is another thing to keep in mind if it's your parents who need this care. If Medicare determines that you stop making progress, they'll quit paying. And I have seen them do this because somebody gets frustrated with the rehab and feels like they are not making enough, excuse me, of an impact. Or maybe they feel like they don't need to be doing rehab. Or maybe they're just tired of it, or maybe they have some dementia and they don't understand why they're doing it, and they will refuse. And so there'll come a day where they say, I don't want to get up and walk down the hall. I don't want to do this anymore. I don't want to do my leg exercises. And when you do that, Medicare can use that against you and say, okay, well, you refused. You're not making any more progress. We're done. This isn't rehab anymore. Now it's long-term care. So that's the thing. Also, make sure that if there is rehab going on for your parents, that you are kind of staying in contact with the facility and make sure that you understand, what's going on with them. And if they are refusing, make sure you understand why, because this can really be a problem. This has caused huge hospital bills for people before that I've seen, because they are, they're having a bad day and they want to quit rehab.
Yeah.
They tell them about it, and then somebody tells Medicare, and Medicare says, "Oh, you're done? Well, we're done." So be real careful of that. Long-term care insurance. This pays for a portion of long-term care each month. These policies don't generally pay the full amount each month, and they might have a time limit or a total payment limit, or both. These premiums are really expensive these days. And they won't generally pay a family member to provide care. So this is a thing to look at. If your parents have long-term care, if you're providing care for them, you might look at using this to get some care that this policy will pay for, that you can then supplement. Generally, they're not going to pay a family member, they'll pay a professional. Some of them pay for in-home care and some do not. Hybrid policies are policies that are both long-term care and life insurance. And that helps you keep the money you pay in premiums in life insurance in case you don't use the long-term care benefits. Partnership policies, I won't get too much into those right now. Veterans benefits, VA aid and attendance ratings benefits. This is a pension side benefit, and it's actually a rating. So if you are getting a VA pension, you can get an aid and attendance rating, meaning that you need the aid and attendance of another person. And that's a monthly stipend that gets paid directly to the veteran or the spouse of the veteran. And then that money that veteran then can use to help pay for their care. You must be a wartime veteran, someone who served at least 1 day during wartime and served at least 90 days or had a medical discharge if it was shorter than 90 days. And you must have anything other than a dishonorable discharge. This is a means tested benefit, just like Medicaid is. So if your parents are veterans, or one of them is a veteran and the other is a spouse, and they need care, they can use these benefits to help them. But you're going to want to make sure that you go through these means tested requirements as far as how many assets they can have, what their income can be, and if they've gifted anything in the last 3 years or not. So I'm going to pull up a little bit more detail on this here. So your monthly medical costs must exceed your monthly income. And that's what they call the income for VA purposes. And if it's less than the amount that you would get each month as the maximum stipend amount, then you can get these benefits to make it up to that amount. So maximum amount is about $2,300 for a veteran, and it's about $1,300 for a spouse of a veteran. Your assets are limited to $130,773. That does not include your residence. And then again, the maximum monthly benefit is based on whether you're a veteran or a spouse, and also how many dependents you have. If you gifted assets in the previous 3 years, then you are going to get denied benefits for a length of time, 1 month for every $2,300 gifted, up to a maximum of 33 months. So how can your parents get Medicaid? Medicaid is means tested. It's got medical requirements, income requirements, and asset requirements. I'm going to go through these. I'm going to talk a little bit about gifting. So I'm going to go back then at that point in time and re-emphasize about the caregiver contracts. And then I want to talk about estate recovery, Medicaid liens, assets owned by the decedent, the person who died. And then also caregiver child transfer, which applies specifically to the cases that we're talking about today, where we have adult caregiving children. So Medicaid is the big one. This pays for more than 60% of long-term care in the United States. It's federal and state. It's funded by both, and it's run by the states. But again, there are federal guidelines that all the states must also follow. Pays for care in any setting, from in-home up to skilled nursing. You must participate most of your income towards your care, and Medicaid pays the rest each month. So this is how it works differently from VA. VA is a monthly stipend that comes in, but it's limited. It's got a top limit. Medicaid, you take your income and you pay it towards your care, and then Medicaid makes up the difference between your income and how much your care costs. But then you get to keep some money each month for personal needs allowance. It's means tested, again, income and asset rules. And there are ways to plan ahead to incorporate Medicaid planning and preserve assets when a person needs long-term care. So this is another thing that as a child caregiver, you want to think ahead about. So if you think your parents might need Medicaid, and believe me, more people need Medicaid than ever think they need Medicaid. So the sooner you go and talk to somebody about what you might want to do to plan ahead for Medicaid, the better off you're going to be, because once your parents are on Medicaid, they don't get to keep much of their monthly income at all. So what you try to do with Medicaid planning is set aside a chunk of money that can pay for the things that Medicaid doesn't pay for, while Medicaid pays for their care. There are plenty of legal above board ways to do that. The sooner you go to talk to somebody about that, the better. The Medicaid requirements. In most cases, your cost of care must exceed your income, because you don't need Medicaid if you can pay for your care with your income. You must require assistance with 2 activities of daily living, or be blind and significantly cognitively impaired and need help with one. So if you have dementia or you're blind, then you only need to require assistance with 1 activity of daily living. If you're single, your assets are limited to a house, a vehicle, a prepaid burial plan, your personal property, and $2,000 in other assets. If you're married and your spouse doesn't also need care, then your spouse may also keep any amount of equity in the home. An additional, these are Washington numbers, an additional $58,000 in property, or up to $128,000 if you're in skilled nursing. The calculation for that difference is a little more complex than I want to get into today, but just know that you should go talk to someone. If your parents go into skilled nursing, you should go talk to someone right away, because the ways that we preserve assets for Medicaid when someone's in skilled nursing are different from the ways that we do it when they are in assisted living. So that's you maybe have a plan ahead of time that you and your parents have worked out, and you are expecting that they're going to need assisted living at some point in time. Well, if something happens and they go into the hospital and then they go into rehab and then they end up in skilled nursing, you want to go talk to somebody sooner. That may change the plan, because the strategies that we use do definitely change when somebody's in skilled nursing. So that's a thing to watch out for your parents as well. And then again, the gifting. So in this case, it's a gifting of 5 years prior instead of 3 years. So Medicaid is 5 years, VA is 3 years. If you did gift, then you're going to be penalized 1 month in Washington, every $10,374 you gave away. That number, that divisor number, changes from state to state. It is the average Medicaid rate for skilled nursing in that state. We're a little high here in Washington. Idaho is about $7,000. It varies. But that number, you can look that up on the internet to find that number anywhere. So you get penalized not 1 month for every amount that you give away that equals that state's divisor. There are exceptions for the penalty period for gifting. I'm going to talk just about one of them really today, because this is the one that happens to matter more to caregiver children than others. So, caregiver child transfer. And this is a way to transfer a home, which ordinarily a Medicaid recipient, if they are receiving Medicaid, you can get Medicaid and have a home. But if you die and you still own that home, then there's going to be a lien after you die on the value of that home. Or if you need to go into a facility and you're not living at home anymore, and you don't intend to return home, then you might have to sell that home in order to get Medicaid, in order to not have the value of that house count against you. So when we look at Medicaid planning, one of the things that we are always adding to that thought is avoiding estate recovery. And so with the home, one of the ways that we can avoid estate recovery is to gift it to a caregiver child. These rules about caregiver child transfer are strict, but they're pretty simple. So in order to do this, first of all, you must live in the home. You must live in the home for at least 2 years while you are providing care for your parents or parent. That care must have kept them from either needing Medicaid or facility care. So it either kept them from going into a facility or kept them from bringing in-home care that Medicaid would have paid for into the home. And this one is the one that gets messed up. The care must have happened immediately prior to the need for Medicaid benefits. If your parents go from needing care into skilled nursing, you're okay. But if they go from needing care to privately paying for care somewhere else, not being Medicaid qualified, you didn't provide that care immediately prior to what they call institutionalization. Institutionalization does not mean they went into an institute or an institution. What it means is that they required Medicaid, that they were qualified for Medicaid, or that they went into an institution such as skilled nursing, or it can also actually be like a mental hospital. But that care must have happened immediately prior to the need for Medicaid benefits. So if you were going to do a caregiver child transfer, under no circumstances do you want your parents to leave the home before they are out of money, unless they're going into skilled nursing. And that's Vital. It's vital. And that is the place that this stuff gets messed up all the time.
Okay.
So if you're planning on doing this, great. This is actually a way that the state's trying to allow for some reimbursements to children who are trying to provide this care for their parents so that the state's not paying for it. However, you've got to follow these rules very carefully. And then finally, you need a doctor's note that specifies the type of care and that it was necessary for your parents to remain home or off, and off of Medicaid. That doesn't have to be really, really, really thorough as far as how the care was provided, but they are going to want to know, you know, what did you do for your parents, and that it was required to keep them safely at home and not on Medicaid. So just a few final takeaways. First of all, talk to your parents about their estate planning documents. If they don't have any, encourage them to at least get powers of attorney, if nothing else. Because if you don't have that, again, you're going to end up in that guardianship world, and that's not going to be good. So try to at least have them get powers of attorney. If you're getting paid to care for your parents, make sure there's a proper written agreement in place. Have it looked at by an elder law attorney or drafted by one. If you live with your parents or they live with you, talk to someone about a possible caregiver child transfer of the home if they ever need Medicaid. Even if the home is your home, go and talk to someone, because if your parents have a lot of excess money, they can always buy a portion of the home from you, have you provide care for a couple of years, and then when they're ready to get on Medicaid, transfer that back to you. So it's to preserve some of the money of your parents. And again, finally, there may be lots of benefits available to your parents, even if you're the one assisting them with care. So go talk to somebody, go find out what might be available. You can be surprised by the things that are available. And sometimes people come in and just have no idea. So I would say talk to them, go talk to someone. So finally, if you have any other questions, I'll be happy to answer them. And of course, always.
I actually do. So we have a really fun situation going on with my dad, and I'm sure that I have never really gone into depth with it. But so dad went into the hospital on March 30th. We did he had all the supplemental insurance. They paid for the 100 days, blah, blah, blah. He's been paying out of pocket. However, my sister lived with him for 3 years prior, basically taking care of him. I mean, he didn't really need care, but you know, he couldn't live on his own. And so he still owes on his house, and she has been making the house payment since he went in. However, we've got about 2 years worth of an IRA that we're paying out of pocket. We're paying 12 grand a month out of pocket. My biggest concern for her, because the house goes to her, and we made that very clear in all of the documents way prior to any of this, is that she's going to lose the house.
So possibly looking at doing a caregiver child transfer.
Okay. I mean, but can we at this point, if he's in skilled nursing?
Yeah, so skilled nursing is the one situation in which you still can.
Okay.
So
even though he's paying out of pocket?
Yes, because it's skilled nursing. So that is generally institutionalized. So
okay.
If he's in skilled nursing, as long as he didn't pay out of pocket for assisted living, then he should still be able to transfer the house to her. So I would definitely talk to somebody about doing that and facilitating.
Okay. That's what I told her. I said, I don't know. And that's why I'm watching these, is I don't know what I need to do, but I need to fight for you, because I don't want you to lose that house. You know, I mean, that's my main concern.
Definitely. Caregiver child transfer. Yeah.
Okay. I will talk to her. I don't know what we've got for attorneys in Casper, Wyoming, but